Once we have ruled out the possibility that a purported acceptance is in fact a counteroffer, we must then ask whether it conforms to the general rule that acceptance must be communicated to the offerer. This is a general rule, therefore it does have its exceptions. To make sense out of the case law, you must recognize that the courts have manipulated the concept of communication and developed technical rules to determine whether a particular acceptance has been successfully communicated. Then there are some circumstances when the courts have discarded the rule completely and allowed an acceptance to be binding without communication. Now let's look at different types of communication that we are going to discuss in a moment, and side by side we will see when this general rule that acceptance must be communicated is discarded. In other words, what are the exceptions to the general rule that the acceptance must be communicated? The two types of communications are instantaneous and non-instantaneous. Look at these two situations and identify whether both situations fall under the category of instantaneous or non-instantaneous category. In the first situation, you and I are standing in a park. I offer to sell you my collection of CDs. You tell me that you accept my offer. In the second situation, you and I are having a phone conversation. I offer you to sell my collection of CDs and you tell me over the phone that you accept my offer. Both situations fall under the category of instantaneous communication of acceptance. Think about the first situation again, where you and I are standing in a park. What all can go wrong when you instantaneously communicated your acceptance? What if I was too occupied looking at a cute little puppy in the park and did not pay much attention to what you said? What if I got bored and completely zoned out and my mind did not register your words? In such a case, if you reasonably believed that acceptance was indeed communicated, courts are likely to think that it was communicated. Okay, what if an aircraft drowned out your words? Is it reasonable for you to believe that the acceptance was communicated? In the second situation, where an offer was made over the phone, what if the phone line went dead? After this lecture, please read Entores versus Miles, 1955. In this age, most of the transactional communication takes place over emails and texts. Are emails and texts instantaneous? As compared to post or mail, yes, they seem to be instantaneous. However, there are two arguments. One, communication takes place at the instant an email or a text is sent. Second view is that email or text only arrive when you choose to access them. Courts are yet to decide clearly on this matter. However, by looking at other cases involving other types of instantaneous communication, it is safe to assume that if the offeree, the one who is accepting, reasonably believed that the acceptance had been received by the offerer, when in fact it had not, then the success of his communication will depend on the fault of the offerer. For example, if the offerer forgot to pay her internet bill and therefore did not check her email, it is likely in this case that she would be stopped or barred from denying that acceptance was received. Let's now look at non-instantaneous communication of acceptance. The major example is communication through post. Cases dealing with acceptance by post are exception to the general rule that acceptance must be communicated. Postal rule decrees that a posted acceptance is binding from the moment of posting without any communication to the offerer. Law here favors the offeree. On Monday, Sarah posted an offer letter to sell her jewelry to Jennifer. Thursday evening, Jennifer received the offer letter and sent acceptance letter. On Sunday, Sarah sold her jewelry to Selma. On Monday, Sarah received Jennifer's acceptance letter. Contract was made at the time Jennifer posted the letter. What if Jennifer's acceptance reached Sarah not on a Monday but on a Wednesday that week? And Sarah waited for Jennifer's acceptance until Monday, when it was expected to arrive, and sold the jewelry to Selma on Tuesday. Can Sarah argue that Jennifer's acceptance was too late? In Adams versus Lindsell, defendants mailed their offer to sell on the 2nd of September 1817. The defendant's letter was misdirected and did not reach the plaintiffs until 7 p.m. Friday the 5th. That night, plaintiffs accepted defendant's offer and mailed it directly back in a timely manner. It was received by defendant on the 9th, but they expected to receive it on the 7th, and in the meanwhile had offered and sold their wool to another person. Plaintiffs brought suit for the losses they sustained by not receiving the fleeces. The Court of King's Bench upheld the rule of trial court that when forming contracts by post, acceptance is valid from the time of posting a letter containing language of same. Because defendants, in their offer, notified the plaintiffs of their terms that they would await acceptance in the course of post, they were bound by the terms of their offer until it was accepted or until the terms of the offer had expired. Visit our website for some exam tips on postal rule. Feel free to start a discussion of postal rule in the comment box. You will get a chance to learn more about the views of other students taking this course.